Hello everyone, and welcome to the Great Cases series of talks organized by Vidhi. It's our great pleasure to have Mr. Anand Grover here with us today, who will be speaking to us about Novartis versus Union of India, where he represented the Cancer Patients Aid Association. So Mr. Grover, as many of us will know, is a designated senior advocate at the Supreme Court and is a founder member and director of the Lawyers Collective, where he heads the HIV/AIDS unit. He has appeared in several prominent matters with implications for human rights for vulnerable and marginalized communities across the country. Some notable examples include the NAS Foundation case and NALSA, the Bhopal gas tragedy case, as well as the Olga Tellis case. He was recently appointed the special public prosecutor in the 2G corruption case and served as the UN Special Rapporteur on the right to health between 2008 and 2014. We're glad to have you here, sir. So just to give a brief background to the case, for those of us unfamiliar with it. So in 2005, India made certain amendments to its patent law, and for the first time, we recognized patents on pharmaceutical products. What these amendments also did was introduce and incorporate certain crucial flexibilities that could ensure that the interests of public health could be safeguarded. So within this context, Novartis, which is a multinational pharmaceutical company, applied for a patent on its anti-cancer drug called Gleevec. So Gleevec, for those of us unfamiliar with it, is a drug that is crucial for people suffering from certain kinds of cancer. And Novartis had plans to price this drug out of the reach of most of these people. So they made an application to the Chennai Patent Office, and the patent was rejected there on grounds of a certain provision in the new patent law, which basically states that only truly innovative drugs need to be granted patents under that law. So this decision of the patent office was challenged before the Supreme Court. And in this case, in Novartis versus Union of India, the Supreme Court upheld the decision of the patent office. And now this decision has major implications for access to medicines and the right to health in this country, as well as our national sovereignty. So I'll now hand it over to Mr. Grover to talk about the case.
Thank you. Thank you very much. I'm glad to see that most of the audience are very much younger to me and Montek ji. We are the three oldest people here. It's really a very good thing, because most of the time when I address access to medicine meetings, most of the stalwarts are my age or older than me. So it's really a pleasant surprise, and I want to thank Vidhi for having young people interested in the Great Case series. Novartis was, of course, a very involved case. I'm going to keep the slides for you and distribute them so you can use them, but not try to go into detail. Give you a flavor of the patent law in India, the concepts behind it, and they're not very complicated. It's only when you do cross-examination of experts, which I'm going to do on Monday to Friday, in another very important case of another anti-cancer drug, androgen hydrochloride, where you really need to know the chemistry of it. Otherwise, the concepts are simple for policymakers, and there are a lot of issues which remain to be answered, especially with the new government, which has been trying to understand, if I may use that phrase, and coming out with the responses, which are sometimes difficult to understand, but I'll just allude to them at the end, which can be the basis of questions later on. So on with the show, as it were. The basis of the Novartis case is in the context of the right to health. You don't have to read the slides, but if you have the speed, like a lot of lawyers do, you're welcome to it. The right to health has been understood in international covenants and treaties. Now, international covenants and treaties, which actually also feature in the Novartis case, are very important to understand. We don't have to go into detail, but they have binding effect. But there are different types of treaties. The international human rights treaties, like the International Covenant on Economic and Social Cultural Rights, doesn't have the same binding impact like commercial treaties, like TRIPS agreement, or say free trade agreements. in the free trade agreements, like TRIPS or other agreements, if you don't comply and do not introduce laws pursuant to that, you have sanctions. Whereas human rights treaties, unfortunately, though they are the highest obligations in terms of law, there is no sanction. So there's an issue. But within the international covenant and treaties and international human rights law, as it is commonly known, there are a large number of treaties which explicitly talk about the right to health. And the reason I'm talking about the right to health is because the right to health under Article 12 of the Covenant on Economic and Social and Cultural Rights has Article 12, which talks about the right to health. Now that is a different understanding from our understanding in the constitutional sense, in the Indian constitutional sense under Article 21. And one of the lacunae in our jurisprudence, and that's one of the reasons we started a website, which is the website on right to health. In fact, it's the only website where you can get translated judgments from all over the world. And because of that, the government has attacked us. That's one of the features of the attack. And I welcome all of this because it allows us to talk about these issues. But it has all the translated judgments from Latin America, France, etc. So if you want to know about the right to health jurisprudence in other countries, you can actually download summary judgments as well as full judgments. Get to know. Coming back to General Comment 14, which is the elaboration. Each article on these 8 treaties, the most important human rights treaties, there are committees set up which actually elaborate those rights through what are known as General Comment. So General Comment 14 elaborates the right to health under Article 12. Now what is important is that the right to health as understood in Article 12 features essential medicine as a core obligation of states to make them available, accessible, acceptable, and be of good quality. Now these terms have meanings, they are terms of art. So availability is how many people need it? 100. Are there 100 units? That is different from accessibility. It's not me. No. How many years? Accessibility is geographical or economic. So affordability is part of it. Then they have to be acceptable because good services and facilities in the right to health have to be acceptable in cultural terms also. Take an example of women. In our countries, South Asia, women go to the doctor with hijab or ghungat. Can the doctor say because you wear hijab, I will not actually? No. So those issues have to be taken into account. So that's acceptability, and they have always to be good quality. So these are the essential elements of the right to health in the context of essential medicines. Also, the obligation of the state, which I'm not talking about here, the obligation to respect, protect, and fulfill. You don't have to go into that, but essential medicines are a core obligation. So if you don't get essential medicines, actually you can go to court and ask for it and you get an order. As we did in the Sankalp case for antiretrovirals. So that is the constitutional background. Same thing obtained in India to a different level under Article 21. We don't have an explicit right to health in our constitution, unlike a lot of Latin American countries and African countries, but the right to health has been read into Article 21 of our constitution. But as I said, one of the major lacuna in our system is there is no jurisprudence. So in fact, a lot of times the judges ask me, what are we going to do about it? I said, look, there is already jurisprudence in international law. Please read those judgments and let's follow them. So we also follow the principles of international law to a large extent. And I'm not getting into that, but if we want, we can. Now, what is so peculiar about India? As was mentioned earlier, we did not have patents from a particular period. Prior to 1972, there was the British law. And actually, what was the position in India, people don't know. But we had the medicine prices were the highest level in India compared to the rest of the world. So you had a position, okay, that everybody settled down. There's some problem. If you can take your seat, then we can. In terms of historical development, patent law in India is very different from the rest of the world. And because of the changes in 1970, to which I must thank Mrs. Gandhi, it's very unpopular nowadays. She was very unpopular with me during the emergency. And we are a group which was attacked both by the Congress as well as the present government. But Mrs. Gandhi did a very, very good thing, which is she introduced the patent law in 1970. Because of that very simple change, what was the change? Patents are of two types: products and the way to make the processes. So product patents, if you have them, if I have a product patent, I have an absolute monopoly. I can exclude you. There is no competition. But if there is only process patent protection, then there is what I call relative monopoly. Another person can come and make the same product through a different process. And that is the Indian pharmaceutical USP. So there's a very famous story. There were so many processes, and the Indian came up with I don't know the number. But it's like, we are the argumentative Indian. I like to give these anecdotes because they make the thing more spicy. Okay? I have a very good friend in Thailand. One of the persons who actually led the fight against HIV. One of the most important things in HIV was to promote condom use. So, if you go to Thailand in Bangkok, the best restaurant for Thai food is actually called Condoms and Cabbages, and is run by a very famous senator, ex-senator, Michai Veeravaidya. So he had actually started the condom promotion program among sex workers in Thailand. And we were just starting off, we were not willing to face the reality. We've actually done a very good job, and because of following Thailand, but with our own indigenous experience, we were able to do this. So I requested him, I said, please, Michai, come to India, explain to our bureaucrats why condom promotion is so important. He said, no. I said, why? He said, there are two arguments, the third one is with the Indian, and your bureaucracy will never listen to me. Because we are so argumentative, which is a good and a bad thing. Now, a good thing in the patent law, because we were thinking differently, we realized that if you actually do not protect product patents and only have process patent protection, then you can actually have a competition. Okay? And that's exactly what happened. From 1972 onwards, you had a complete change. The Indian generic industry at the time of independence was really very low. Prices were very high. All the patents, okay, were owned by the multinationals, mostly British. From 1972 to 1995, there was a sea change. And what was the sea change? First, the Indian generic became dominant in the Indian market. Secondly, they started having innovations in the processes. And thirdly, by 1995, Indian generic industry became the source of all the essential medicines, particularly antiretrovirals, in the developing world. Now this is very important. So there is a very good study on this by Brenda Wade, which you can have a look at. So that's why, for example, when the India-Africa Summit was held in the beginning of this year, Kenyans were so much worried that if we change our IP, our laws, then they will suffer. And when the patent amendment changes were taking place in 2005, all countries, including the UN, represented to India that please make sure that you make medicines available, because of the law which prevailed from 1970 to 1995 and 2005. Now 1970, the law changed and the generic industry really shot up. So I want to just show you this chart, and I mean you can have a look at it, but very importantly, bulk drug formulation went up, formulations all went up. 88 is a crucial year. Economist Mr. Montesing will note this. From 88 we became net exporters, and we have never looked back. And the changes in policies which are taking place and which take place may have deleterious consequences later. I'll come back to that. Now, after 1970, I've not put this in the slide because this is a Novartis case issue.
But from the 80s, the US multinational industry, particularly the entertainment and pharmaceutical industry, which is represented by the Pharmaceutical Manufacturers Research Association, if I may use the word, they're the mafia of the industry. Literally, I'm using this word. And I'm sorry to use it, but I'll vindicate every sentence of this. They decided that, like their patent law, the whole world should have the same patent law. Whole world should have the same IPR law. But patent law of the US is as bad as Coca-Cola and hamburger. Let me tell you very clearly. It's bad for health. Okay? Everybody understands this, so I don't have to explain it. Now, they brought about an agreement which ended up in TRIPS. It was done not by discussion. It was done by using what is known as US 301 special and US 301. If you don't agree, we will impose sanctions on you. That is known as good governance in the US diplomatic world. No? And I told this to the US government when I was the UN Special Rapporteur. You don't know how to behave. You're a bully everywhere. But you will learn your lessons in this century when other countries also become powerful. You have to say this to your friends also. You can't bully everybody around. But they're still doing it. That's the tragedy. Now, what they did was, one of the very important things was that they could not get the same laws in the US, but they had the minimum protections for patents and other intellectual property, which is TRIPS agreement. Why did we agree? Because our government thought, our representatives thought, and this is very well discussed in Jayashree Wattan's book, who was our prime negotiator. We thought flexibilities are the most important. We have got the flexibilities, so we can achieve. But they didn't realize that the US, both the pharma and the entertainment industry, have long-term plans. They are long-term players. They're not short-term. They're not opportunists. Who decides what happens in the US government? It's not Hillary Clinton if she becomes president. It's the US corporates, which is becoming the case here also. Okay? Nothing wrong or right about it, but that's the reality. So they have long-term aims. And the long-term aim was partially achieved by the TRIPS agreement. The long-term aim is now being achieved through the free trade agreements. That's the mistake that the Indian government made. Thought that this will end. It didn't end. The free trade agreements are achieving the same agenda which was thought of in 1988. Okay? Now, if you understand that, you understand what their aim is. If you don't, you fall into that trap. So, anyway, the TRIPS agreement required and mandated us to have product patent protection. Okay? Now, in the meantime, so that had to be brought about not in 1995, 1st January when it was signed, but for different countries at different times. So India had to have it in 2005. But in the meantime, there were certain interim measures, including what is known as for patents exclusive marketing rights. Now imagine this, and there's a case which we are doing in the Delhi High Court. Under the TRIPS agreement, we were bound to have the interim regime of exclusive marketing rights. Was Parliament consulted in having this agreement? No. Parliament actually protested after the TRIPS agreement was signed. They refused to introduce the EMR provisions in law. 3 times it was brought in, 3 times it was rejected. Because Parliament said, we don't agree with this TRIPS agreement. Because in India, the executive has coextensive powers with Parliament on issues relating to which are in the list, in the union list. Therefore, executive can sign an agreement. Parliament is bound, like TRIPS agreement, to enter into the law or bring into force law which is required under that agreement. If we don't do it, as we did not, we were taken to the TRIPS dispute panel. We lost. We went to the appellate dispute panel. We lost. We introduced the provision. What has happened? Your sovereignty is lost. Please appreciate that. Parliament today doesn't have the same sovereignty it had prior to 1995. If we enter into the EU, India Free Trade Agreement, same thing will happen. Parliamentarians are rubber stamping bodies now. And who is determining the agenda on these vital issues? Not parliamentarians, not the representatives of the people, but corporate bodies were sitting in closed doors, only pursuing their own financial interest. That's the problem. We have to think and how to actually change the situation. Now, in the Novartis case, in fact, there was an application made by Novartis to have their EMR. I lost it. I'll show you that. So, I think it's there somewhere. But anyway, they made an EMR application. They were granted an EMR, exclusive marketing rights, not a patent. Okay, and the NATCO and other companies were producing the drug. Novartis went to the Madras High Court, they got an injunction. They went to the Bombay High Court, it was denied. And this was based on the transition provision that if you got a patent in another country and marketing approval, you can get that. You don't need to do that. A very important thing in patents, and this is what the 3D case and the Novartis case is all about. What happens is that biochemicals or chemicals, you make a major change once in 30 years. Then you make what are known as incremental changes. These incremental changes are 99% obvious. They don't really change. For example, from the base, you make a salt. That's obvious. Now you don't need a rocket scientist, a rocket chemist as it were. It's all done by the computer modeling. And there is a way of selecting. There is literature which tells you how to select the best salt. There's a procedure you adopt. You don't have to do much. Similarly, crystalline. But if you make a base, originally the chemical will be a base. Base and acid make salt and water. Salt is more soluble. The second generation of these drugs is salts. Then the pure form is crystalline. Now in most countries, these are known as novel compounds, innovative compounds, they are patented. So the first lot, say for example ganciclovir, patented. Ester is a form of it. It is actually patented later. So the same drug in a new form is patented later, and it lasts not for 20 years but longer than that. Okay? Then new formulations, tablet, liquid, they are all patentable separately in the US. So they get their patent extended. That is known as evergreening, and that's a major problem. And they create what are known as patent thickets. Now if I use the same drug, now for example ganciclovir, ester of ganciclovir, it will have the same compound. The patent is extended. If I use it, I am infringing either of them. Therefore I cannot make it. Though the patent term is 20 years, it goes on for 30 or 40 years. It allows the monopoly to be extended. So that's one feature we have to understand. This is what 3D addressed. Okay? Now, second thing, pricing. This happened. This is 1999, 2000 onwards. The innovator companies who had sued the South African government, 39 of them, they were selling the drugs, please note the price, $10,000 for a course per year. Cipla, Dr. Hamid, he told me, he said, I had no plans to manufacture, but I thought, let me take a gamble. And he said, I'm going to make the drug available at about $500 per year. Instead of 10,000, what happened? He didn't make them immediately. The prices just plummeted. Did they not make a profit? Of course they made a profit. From 10,000 to 500, they were still making a profit. So what is the profit margin? That's why the pharma stocks are always going up. Even in India, they never go down. Because the profits are criminal actually. From $500 to $10,000, imagine the percentage. Is it conscionable? In my respectful submission, these are criminal profits because you are selling these drugs only to people who can afford it. The rest of the people can just die. Now the drugs are actually not even $50 because large numbers are producing this competition. So this is a very important chart. You will understand from this that the profit margins are huge. And secondly, it also tells you, and this is the benchmark, that you need 4 or 5 companies in the competition to reduce the drug to the lowest level. Okay? Another thing, this is very, very important. And this was the basis of introducing 3D in Parliament in 2005. During the period just before that, the last decade or so of the last millennium, the data which was available from the Federal Drug Administration in the US and also from the European Medical Agency showed that drug approvals, please note the figure, 76% had no therapeutic benefit over the other drugs. Only 24% had therapeutic benefit. But more importantly, only 15% were really what are known as new molecular entities or new chemical entities. 85 were just new forms with no change in efficacy. Now this lesson was very important for us to devise a mechanism, because now we were entering from 2005 to a regime where you have to have product patents. So the Indian genius, as it were, came alive, and and that time, there were all the parliamentarians, all political parties were ad idem. They agreed with each other on actually not changing the patent law too much. Even though TRIPS mandated us to have patent law, we had to find a way out. So these were the background facts which allowed us to think. Now comes Gleevec. 2005 we still don't have a patent law. 2003 Gleevec was sold. Please look at the price. 1,20,000 per patient per month. And if you look at the prices now of a lot of the drugs, they are the same. And a lot of people are dying of cancer, hepatitis C. Cancer, hepatitis C, there is no government program. HIV, there is a government program. Okay? Cancer patient, now Novartis was the innovator, but NATCO was able to sell in Bombay because there was no injunction by the Bombay High Court. They were selling the drug at 4,000 to 12,000 a month. Look at the price difference. It's less than 10%. Now, they were also giving it to Cancer Patient Aid Association, who were my clients, at a reduced price at 1,000 rupees. So they have a program. NATCO has a program. In fact, when they did a case, the first compulsory license case against Bayer, NATCO undertook to give large number of free drugs as part of the order, because that was one of the things that I was interested in also. And they did a very successful program. I'm happy that I was able to appear. Now, what is Gleevec? Gleevec is actually, in chemical terms, imatinib. Imatinib is a base. Now, early on it was developed by government funding. 90% of the drugs so-called invented, there is a program. Drug discovery is the first part, where the molecule is invented, formed, and discovered, or whatever you want to call it. Then it is patented. Then is the drug development period, where you do animal toxicity studies, phase 1, phase 2, phase 3, etc. That is development. The actual drug invention is done by mostly publicly funded laboratories in the US, National Institute of Health, etc. And even the money paid for drug development to pharmaceuticals is partly government funded. But they are licensed to the pharmaceutical companies for development and then marketing, and the prices shoot up. And there's a controversy because a lot of the universities own those patents, and the students have found out that they have collaborations with companies and the prices are so huge. Anyway, this was also funded. Then a patent was filed for the base by Ciba-Geigy. Then in 1996, the salt was found, imatinib mesylate. And Zimmerman, who was one of the inventors, found out there is no difference in efficacy between the base and the salt. It can't be, because when it goes into your body, it is the same. There is no question of efficacy, but it may be more soluble. That's not efficacy. Now, the third thing was, so you have the base, the salt, crystalline form. The beta crystalline form was made, and in Switzerland in 1997, 18 July, they actually made the application. And as according to the Patent Cooperation Treaty, you can file an application in a convention country or the country which is a party to the Patent Cooperation Treaty within a year, and then you get the priority date from the beginning. So they filed it in 1998, but because we had the period of transition from 95 to 2005, the applications were only open in 2005 for examination. So in the meantime, they also made the they got the approval for beta crystalline form in the US. Then in 2002, they applied for that EMR. And as I said earlier, EMR was granted, but injunction was not granted. Here, this is it. We also filed a petition through cancer patient to actually make sure that the EMR is revoked because they did not fulfill the criteria. But by the time the matter came up, what happened was the patent, the full-blown patent regime actually was kicked in by the 2005 amendments. And 3D was actually brought in. After that, in September 2005, we were the first people to file the opposition. Okay, what does 3D say? Now, please remember, what did I tell you? Because this is not a political talk, but a pedagogic talk. What did I tell you first? Remember that evergreening? New forms. Secondly, this thing, 76 and 85% are new forms. So we had to tackle that. So we came up. Now, actually the civil society, and you know, at that time, the left groups, CPI, CPM, the Congress, they had an effective role in the whole thing. But there was no real difference between BJP or any other group. But we were able to move through the Congress and the communist parties, the civil society. We came up with the idea that no new form should be patented. But by the time the matter came to Parliament, the multinationals also came to know of it, and they won't have any of it. So there was a compromise. They said, okay, no new forms can't be there because that's too broad. So what was the compromise or the modus vivendi? A mere discovery of a new form of a known substance which does not result in the enhancement of known efficacy of that is the known substance, or the mere discovery of a new property. We're not concerned with that right now. But there is a known substance, it has efficacy, and the new form should have enhanced and significantly enhanced efficacy. That's the crux of it. And then the explanation. And that is for processes also. Explanation. So this is what is known as a deeming fiction in law for the purposes of this clause. So if there's a known substance, the salt or the ester, ether, polymorph, metabolites, etc., these are new forms of the same substance. This is a deeming fiction. So in the case of Novartis' imatinib, the beta crystalline form is a new form. So they have to show enhanced significant efficacy. So what did they do? First, I'm not getting into the EMR. As I told you, base plus acid, salt plus water. Okay, and in this case, imatinib free base with methyl acid gives you imatinib mesylate. So it is the base and the salt and the crystalline form, which could be alpha or beta. So section 3D says it has to be a new form. Efficacy should be significantly efficacious. The known substance was imatinib or imatinib mesylate because they had disclosed that. And the new form, according to us, was the crystalline form. And our argument was, in the patent opposition, there is no difference in efficacy in terms of 3D. There were other arguments also, but we are concentrating on 3D. Now, there was a difference in the physical properties of beta crystalline form and the alpha crystalline form. And what is the advantage? Our beta crystalline was free flowing. You know, like your salt in your home, how does it free flow? Because it doesn't collect water. It's hygroscopic otherwise. You add something to it, make it free flow. So it was also less hygroscopic. It doesn't collect water. Moreover, it is thermodynamically stable, meaning temperature variation is still stable. These are the advantages in terms of physical properties. They try to make out, Novartis, that these are aspects of efficacy. We said no, these are physical properties, they do not contribute to efficacy. So, now there are three things in patents. First of all, it has to be new. What is the meaning of new? New is very simple. Is it disclosed in one article or patent, one publication in any part of the world before the priority date? That's very easy. Because you just say, is it there? Then it also has to be enabled. That means it must be actually working. You can't just have a hypothetical substance. It actually has to exist. That was another issue. But the more difficult thing is what is known as the inventive step or not obvious. The idea is that there is the prior art, which is the state of the art now, and the invention has a jump in the state of knowledge or an advancement which is not obvious to the person skilled in the art. So there is a state of the art and there is a jump. That is known as the inventive step. Now that's very difficult. You only, because ultimately it's a matter for a skilled person who is cross-examined to tell you whether he or she thinks. Sorry, transgenders also have to be he, she, what is the word for it? TG. They think whether it is obvious. Okay, so that's a very tough thing. Thirdly, it must be industrially applicable, means it must be used in industry. In the US it's utility, useful. So these things are very important. So the patent applicant has to show all these three things. Opposition can knock out the application only on one ground. Now add to that, what did we add? 3D, because that was a flexibility. Because the TRIPS agreement says it has to be new, but we won't tell you what is new. You devise your own system. And that was what we devised. We also devised in the inventive step. Normally in other countries, in other laws, they'll say, is it obvious to the person skilled in the art, the inventive step? We have said, is there a technical advancement or a commercial success or of economic significance, or both, feature of which is not obvious to the person skilled in the art. So there's a rolled up thing which is different from other laws. And Justice Manmohan Singh in his judgment in the Adler-Tennant case, he has actually alluded to this and said our patent law is different from, which is correct. So remember that when you actually discussed the law. So opposition, basically we said that free base is disclosed, the salt is disclosed, and we showed other prior art. What happens is, before the priority date, you show other art, which is publications, scientific publications, patents, specifications which are published, they have to be published to show that is either not novel or it's obvious to the person skilled in the art. So that's what we showed. So we said it's not novel, it's not inventive, and also on 3D we made the submission that in fact it's a new form, there is no efficacy change, and both imatinib and mesylate were known. Beta crystalline form has no difference in efficacy. That was the basic case. We also argued on what is known as the priority date, because this is before the Patent Amendment Act, but that was not decided in our favor, so I'm not getting into it. Novartis said that only imatinib is disclosed, and it's a two-stage process from imatinib to the salt and the salt to the crystalline. So they said it's not what we are saying. That was the basic argument. Patent controller said it is anticipated because it's the crystalline form. Anybody can make it. First thing that you do after you get a base is to get a salt. Second thing you do is to get a crystalline form. And these are known in art. So it says obvious, it's not inventive, and beta crystalline form is hit by 3D because you have not shown significant enhancement of efficacy in that case. Now in the meantime, I must tell you that what had happened was the 3D was decided against Novartis by the patent controller. So Novartis, what did it do? It doesn't go to the appellate authority, which was the High Court at that time. It files a petition in the Madras High Court challenging the virus or the constitutional validity of 3D on two grounds. It's arbitrary, nobody knows it. They said, what is this significant efficacy? We don't know anything about it. Well, to their surprise, or actually they knew all along, they were making applications every day practically in the European Medicine Agency and regulatory authorities, saying that their compounds are significantly more efficacious because we had taken the wordings and the text of 3D from the European directive. So they knew all along. But there are people who are capable of lying. That's the norm. It's very common in litigation. Please is the most common thing. And in our system, that's the norm. That's not the exception to the rule. It's the rule. I'll tell you, I am so amazed when lawyers, without any blinking of the eye, they will just make a statement up, which is completely a lie. I'm amazed at it, because I was brought up saying you are paid for your brains using the truth. But I'll tell you an anecdote if you don't believe me. I had a junior from Delhi. I'm not blaming Delhi, by the way. I love Delhi, though I'm from Bombay. But my junior, she was very bright. I won't tell you who she is. She's a very bright lawyer in Delhi right now. And I'm very happy for her. So one day we were cracking a case, and I said, oh God, we don't have that document. What? Why don't we make it up? That was a response. I'm not telling you an untruth. I said, if you ever do that in my office, you will be kicked out. Lawyers are paid for brain, not for this, sir. You understand? But it's it's normal. Now, in the latest case of Sofosbuvir, in the US, the scientist who deposed on behalf against Gilead, he lied. And on that basis, they had to change the order. Damages were not paid against Gilead. Complete white lie. This is normal. It's not abnormal. It's a very bad thing, but that's the system everywhere. So they said we don't know anything about significant efficacy, and we showed every other day they are making applications based on that concept in Europe, because that's the European directive, on the basis of which we had borrowed the text actually from the European directive in 3D. Secondly, they said it's vague. Sorry, that is the first argument. So the High Court said, sorry, it is not vague, it's very clear, you used it. The second argument was, it doesn't comply with TRIPS. Okay, so basically, if it doesn't comply with TRIPS, then the law is very clear. TRIPS has its own body called the dispute panel, and the appellate dispute panel. Please go there. Switzerland hasn't gone there. Novartis can't go, only states can go. Because none of the states have gone to the dispute panel saying that 3D is not compliant with TRIPS. Now it's how many years? More than 20 years. No, 2005 to 2007, 12 years, nobody's gone. So anyway, what Madras High Court said was very important, that this is brought in, 3D is brought in to the law to promote the rights of citizens to life-saving drugs, to discharge the constitutional obligation of good health. So it's very clear, that's the purpose. So it's a very good thing. Now they were told to go to the IPAB because the High Court, the law had changed, and they went in appeal to the IPAB. The IPAB, that's the Intellectual Property Appellate Board, actually the person who was there was very good in his law and chemistry, a very, very good fellow. Basically, the appellate authority said, it is novel, it is inventive, but is hit by 3D. So we were saved because of 3D. Okay, I'm not going into detail because I think there are questions. Supreme Court, they directly went, they didn't go back to the High Court, because normally you go by writ jurisdiction under 226. They filed directly in the Supreme Court. Okay, Supreme Court judgment basically says there has to be a balance. Invention and patentability are two different distinct concepts, and 3D is a second tier from the inventive step and the novelty step and the industrial application. So that is one tier, this is a second tier. And they said 3D applies to Novartis, and it's the obligation of the applicant to show that the new form has significantly enhanced efficacy over the known substance. That is they who have to show in the specification, and it's at the specification stage, not later, because the priority date is very, very important. And they said as far as flow properties are concerned, thermodynamic stability is concerned, lower hygroscopicity is concerned, these are physical properties which may lend advantage, but they do not constitute anything to do with efficacy. And efficacy, they said, is therapeutic. So it is borrowed from the Darlan Medical Dictionary, the concept of efficacy. I mean, I was trying to be over clever. I said efficacy is different from what is known as potency. In most of these clinical trials, they do what are known as potency tests, which is depicted by IC50. How much drug concentration is required to kill 50% of the sample. that is about potency, which is different from efficacy. But Justice Aftab Anand was too clever for me. He said, sorry, this is too technical, go to another court and decide that issue later on. But it was a very good judgment, and efficacy is the ability to produce the desired or intended effect. And it would differ from, you can't have the same measure for, say, a chemistry or chemical product and a physical product. You can't say it should be 1% or 2%, it's different. And in the context of medicines, it has to be therapeutic efficacy, and that has to be interpreted strictly in terms of 3D. And they also argued bioavailability is another property which is important. Bioavailability is, if I take a drug, how much of it is available to the target site, the liver or the heart. And if there is more available, it will have more efficacy. That was their argument, but there doesn't translate like that. So you have to show not bioavailability, but the next stage, which is efficacy. So basically, incremental innovations are not allowed unless you have significant efficacy. That was how the Novartis appeal came to be rejected. Now, I want to stop here and give you just an idea of the future challenges, just taking into account what has happened in the past. As I mentioned to you earlier, the TRIPS agreement was brought about by the US entertainment and the pharmaceutical industry. They have what is known as US 301 special, that's a statute in the US under which they monitor, please appreciate, they monitor whether Indian law complies with their understanding of what should be the law. Can you believe this? Can we have a situation where we monitor the US law and say, okay, if the US law doesn't agree with what we think, we will impose sanctions on them? No, because the world is ruling according to their whims and fancies. Okay. Secondly, the US pharmaceutical industry and some of our Indian corporates who are represented by the US India Business Council are very unhappy with 3D. They want to knock it off. Thank God they have not been able to do it. And there are a number of other bodies. They regularly not only come and advocate with parliamentarians and bureaucrats, they take them to Washington University, which is notorious for its pro-IP agenda, and they don't want to have a debate with us. Whenever they have had a debate, they have had to walk with swollen faces out of the door. I can tell you that much. They are insisting on that. Now, the other thing is free trade agreements. 1988 agenda is still on. So, all the free trade agreements have the same agenda that they had in 1988. Patent term extension, all those things are there, whether it's the European agreement, US, Trans-Pacific Partnership, every one of them has the same terms. Actually, if they actually have open competition, they won't be able to survive. But because of patents, they have rentier income. That's how they are surviving. It won't last forever because the academic literature on patenting and all IPRs now are practically unanimous. They do not contribute to innovation. Let me be very clear. Please go and get any literature now. 99% of the literature will tell you, except which is sponsored by the industry. All independent academic literature is very clear. IPRs are not contributing to innovation. They are actually hampering innovation. Okay. Third thing, bilateral investment agreements. Actually, we were crying hoarse, before the earlier government, UP agreement, entered into 100 or so, I think 100 agreements on bilateral investment without realizing what happened recently. Because a private group can sue the Indian government can't sue the private under the bilateral agreement, take them to the arbitral forum in Washington and sue them for changing laws which will affect their profits, and they will get billions of dollars, and there is no recourse. The new policy that we have come up with, the regime, is that first you have to approach the Indian court, and if you don't get a verdict in 5 years, which you'll never get in India, that's why they have said commercial, no, please, it's very serious. Well, I'll tell you one thing. If you are a very big corporate or a very big Bollywood actor, including Mr. Salman Khan or whatever you will get your results in 1 year. I'm being very serious and very pained at this. I have 3 cases in the Bombay High Court of people who are victims of the NDPS drug laws. They were convicted, they have filed an appeal. For 10 years, the appeals have not been heard. They have served their sentence. Same judge, the matter came up, before whom Salman Khan's matter came up. He didn't have the time to hear me. But Salman Khan was given expedited hearing within 6 months, verdict of acquittal. I'm not talking about the merits of the case. Who gets priority hearing in India? And now they have commercial courts. Actually, there is going to be no difference. Same judge will be hearing the commercial court, and they don't have the time. Our system is broken. Let me be very clear. So this is not going to work. But anyway, I don't want to get into that. The other point is, now the multinationals have come out with what is known as voluntary licensing. It's a very important concept, very clever concept. It's a difficult thing to beat. The idea for them, we don't have time to discuss it, is to actually make sure that they are able to buy the generic companies, not in terms of investment, but they collaborate with them, so there is no real effective competition. There is a larger access though, let me be very candid. Other point is the IPR policy. Has anybody read this? Please read it. I don't want to say it, but it's laughable. All it talks about is IPR has to be popularized. In schools, in education, it's like a mantra. You must do yoga everywhere. You must do IPR policy popularization everywhere. It doesn't make any sense. What are you going to do it for? Because IPR is not going to give you anything. It's going to give people monopolies who very few select people. 30% of the world's poor are in India. Most of them don't have. You saw yesterday, a woman is being carried on the shoulder. I mean, what are we talking about? It pains you, you know. And we are talking about IPR policy. It's a contradiction. So if you are forced to, why don't you be innovative? We were innovative in 2005. Continue that policy. No. It's not clear whether they are continuing the policy. If you talk to the bureaucrats on the free trade agreements, they are very clear, they are continuing, which is good. But IPR policy doesn't tell you that. Finally, one of very detrimental thing which has happened is, until recently, this year, 2-3 months ago, the new investment policy, FDI, it was 49% without FIPB approval, direct route, automatic route. In brownfield investments, that is the existing companies, a foreign direct investment could be only 49%. Now it's 74%. So any multinational can buy an Indian generic company. What is the forte? What is made in India? I gave an interview once. I said, made in India, the best example. I believe in made in India, by the way. Okay, made in India, the best example is the pharmaceutical and the software industry. What are you doing to it? You are going to destroy it with this simple change. Because there will be hostile takeovers in the later period. What are you going to do? Ranbaxy was sold. See, you have to understand, in the grandfather of the 2 grandchildren, by Mohan Singh, then the second. Those people, when they started, like Dr. Hamid, they had a vision for their industry. We want to serve the nation. Cipla was set up at the instance of Mahatma Gandhi. That was vision. Dr. Hamid still has that vision, I am happy to say. But this generation don't have that vision. That's the problem. I don't want to judge them, but they don't have that same vision, because industry coupled with vision for serving humankind for pharmaceutical industry is very important. Is it asking for the moon? No. We have examples. In fact, large number of the Indian generic industry started off like that. Okay, that is no longer there. So I want to stop here, otherwise the argumentation will never stop. Thank you very much.
Now we can take questions.
Thanks very much.
Anand is the name.
Thanks very much, Anand. That was a really amazing talk. Actually, wanted to ask you about. Yeah, I'm Vidhi Mehta, and I work here at on public health and environment. I wanted to ask you, how difficult was it, how easy or difficult was it to engage the court on the sort of technical matters that were involved?
I was thinking that we'll take 2-3 questions. Otherwise, it becomes.
How difficult it is going to be there now, because I see this globalization discourse is there, and so human rights, that is patient rights and patent rights. So this conflict is there forever. And as you see, we talk about innovation and promoting the culture of dissemination of knowledge. So IPR is supposed to do all that, at least on paper, but they believe in only secrecy and confidentiality and exclusive monopoly. So how to address these challenges?
Hi, Algo and Vidhi. One point that came up during your talk was the fact that Parliament was presented a fait accompli when the executive went and signed this agreement. And it seems to be even with the FTAs and so on, there seems to be a slight issue as to how international law becomes enforceable within our domestic framework. And one thing that I've always wondered is the fact that if you do look at the lists in list 1, entering into treaties is a matter that Parliament can legislate on. So what in your view is currently stopping or has stopped for the last 50 years Parliament legislating on it, saying that for certain kinds of treaties you will need, like it's there in other countries, pre-ratification of Parliament before you can go. So is it time that we start thinking about pre-ratification before we go in and enter?
Yeah. We can come back, no problem. Well, I think, I'm sorry, I don't know your name. I think it's very important. I think there's a need for legislation. Otherwise, you're met with fait accompli all the time. And in fact, there were earlier cases at the times of TRIPS agreement and even later, where they tried to stop the executive from entering into treaties, and the court can't do it. But what we did in our intervention in the court in a petition, we said that we are not asking you not to stop, but you must make all the information available. And this was about the India-EU treaty. India-EU treaty is available partly on WikiLeaks, it's partly available from the right to information from the European side, and all of them show that the only people who are consulted are corporates, whereas people who are affected, who are going to be affected in terms of adverse effects, they are not consulted at all. And parliamentarians in most cases are not even aware of this. So they will be met with a fait accompli. I think there is a need to discuss how to make sure that there is that procedure of ratification. US does it, but it's not true for all countries, because as you know, civil law countries, the system is entirely different. Moment they ratify, it becomes part of domestic law. They don't have to domesticate, they don't have to pass a law. But my experience with the Latin Americans has been very clear. They are very happy for human rights treaties. But you know, there's been a major issue in terms of the TRIPS agreement, NAFTA. And the funny thing is now the US wants to withdraw. I mean, both the candidates have made that clear. Whether they actually do it or not is another thing. Well, I don't think you can pin the blame at globalization. You know, globalization is like an evolving, you know, whatever the technology evolves, humankind evolves, civilizations evolve. So globalization is part of that process. But there are different actors. They have competitive agendas. They have competitive demands. So I think the corporates have got the better of it. But equally, there is more knowledge, more activity from the civil society. So I think they also have to work hard to make sure they are able to articulate their points of view. But I think in countries like India, it is easier to convince parliamentarians about access to medicine and patent law and TRIPS agreement, etc. Now we don't know how things are going to shape, because it's not very clear even now. But as I told you earlier, in the free trade agreements, the Trans-Pacific and the RCEP, pursuant to the Trans-Pacific, there's an RCEP negotiations going on. In that, the same demands are being made by Korea, Australia, and Hong Kong. Okay, and the Indian delegation, I know very clearly because we were consulted by the DIPP, they are sticking to their stand. So I think the government is not going to change the law, but they are trying to bring out changes in the policy, which according to them will have more effective IP generation. You know, but I think the policy is flawed. But at the international level, we have to convince
especially the Americans and the Europeans, that their law doesn't actually result in innovation, but results in huge and exorbitant prices. And you know, for the first time in this decade, the people in the medical field have protested. Large numbers of doctors association have openly written about this. And as I said, the academic community on IPR is very clear now. If you go to the US, 90% of the academics will actually articulate this point of view, that patents are not getting you anywhere in terms of innovation. Well, third, the point that you made, Daniji, in the Novartis case, this was a major problem. Okay, the reason was none of the judges were versed with chemistry, but Justice Aftab Alam was very patient. But the other thing was, the other side has to win. So they gave half truths. I'm not blaming them. I'm not saying they're lying, but they were giving their own version. And but there are some judges who know. The procedure now that is adopted is that actually the evidence is heard before a commissioner. So what happens is, once the patent itself is actually, the patent procedure of grant is through the patent controller in the pre-grant opposition, post-grant opposition, then revocation by the appellate authority. In this there are technical people. All of them are technical people. And the appellate authority, one will be a judicial member, the other will be a technical member. So they are technical people. One is, once it comes to the High Court, there's a huge difficulty. And our system is such that the middle, there's a High Court level where there's a huge bulge, like human beings. So the overload of work is there. The people are not trained, and you can't train people in these areas. If you don't know any chemistry, it's very complex. I can tell you that. I'm just preparing for cross-examination on Tuesday in that other matter. I'm originally a biochemist. It's so difficult because innovations mean you have to read a lot. And of course, you can shortcut it if you have an approach, because you can't read hundreds and hundreds of articles. It's the approach you have. So you can narrow down, but then that has to be understood in terms of the chemistry or the biochemistry or the physiology of it. So there's a problem in there, and unless we are able to overcome that, I don't think. But the major work is done by the patent controllers. Once that is granted, then you have a system of infringement. So once an infringement order is granted, and the interim stage, the generic companies file what are known as counterclaims. So that trial takes place. But with the voluntary licensing procedure, which Gilead has adopted, what is happening is, and this is another thing I wanted to talk about, but didn't have time. But if you want to talk, I won't talk for long. Gilead is selling, say, sofosbuvir, which is a hepatitis C drug. It's actually effective. It may not be innovative in terms of patent law, but it is very effective. It cures hepatitis C. But there's a big dispute as whether they invented it or somebody else invented it. And that's the litigation going on in the US. Now they are selling it at $84,000 per course, excluding diagnostics. Okay? They are not basing themselves on what is the value of getting the patent in terms of costing it. They are saying, what is the opportunity cost? How much would it take you to treat? And if you compare it to that, that's how we will make our profit. Okay? But what they've done is, to the Indian generic companies, they have licensed the drug. Voluntary licensing. Okay? What has happened? All the generic companies withdrew their patent oppositions. So only 3 groups were left, who were all NGOs, and one small pharmaceutical company. So the opposition procedure with the voluntary licensing is given a go by. The other procedure known to law under the statute is known as compulsory licensing. We've had one compulsory license, which is Bayer's, which has been successful, but it's highly litigated. NATCO had to really struggle to get it. It should be available as of right, and that's what the generic industry is saying, that you should have an automatic procedure if certain conditions are satisfied. That we used to have in the old patent law. There is no longer that procedure, but that's a very difficult thing.
There are some questions at the back. Sorry. Oh,
This lady wanted to ask. Are you up? Yes, go on. Yeah, I'll take 3 or 4 at a time. Please tell me your name.
Sunita. Thank you for this enlightening presentation. One aspect I thought I wanted you to reflect and comment on was this recurring problem of a pay to delay entry of generics into the market through outside court settlements. So some of these landmark judgments, such as the Bayer judgment as well as Novartis, seem to have reflected the Indian position in international trade negotiation. But as such, there's no clarity. And you just mentioned about how the Indian government has become pro-industry for that matter without having much information, and that's reflected in the national IP strategy as well. However, the domestic aspect of certain out-of-court settlements when the generics are actually not even entering market or opposing a pharma company's tactics to say have the patents invalidated as a market requirement. What would your take be in terms of regulatory and public interest views? Whether we will probably go the activist way, or is there a requirement for regulatory rethinking or reframing of that? Thank you.
Yeah.
Thank you. Really, thanks a lot for a very interesting talk, which I greatly enjoyed. You know, I certainly endorse what you said, and I've talked to a lot of academics in the US, lawyers in particular, and they would endorse what you said. That basically a lot of the argument that patent protection leads to innovation just doesn't hold water. I'm just surprised, by the way, that we don't use that more. Because after all, that is a relatively open society. So, I mean, if this was used more, people would be a little bit embarrassed. But maybe it needs to be publicized. I mean, Joe Stiglitz, for example, he's strongly against it. You know, so that's one point. Second point is that, you know, IPR conceptually is not about just pharma. It covers the whole ground. So are you not saying that, look, we just want to carve out for pharma? We have no problem, or do we have problems outside pharma with IPR? That's the real issue.
Okay, let me ask. Yeah, sure. I'm bound to be here till 7:30, so that's the written contract.
I'm Shekhar. I'm studying in JNU in Center of Studies in Science Policy. I just wanted to understand about the license evergreening concept. Is it the same application which they continues basically they keep on filing the one application, keep it alive, and keep on filing another application, or it's just a new application? And another thing I wanted to bring in your kind notice about the rules which the company is trying to amend about the testing results, which they want to keep secret for years, and so that other generic company could not obtain them, and they have to.
Data exclusivity. Data exclusivity, are you talking about?
Yeah.
Okay.
Yeah. Thank you.
I'm not sure I understood your question, Sunita. I think you're talking about the overall policy and whether the activists will actually be. Okay, you know, if you look at the situation today, there are a number of challenges. I think the government understands, and the bureaucracy also understands, medicines are very important. They don't want to change the patent law. But with the Prime Minister's Make in India program, they want to attract foreign investment. And the general sort of prevailing kind of propaganda, and that's only propaganda, is that we are unfriendly to IPR, which is completely not true. If you look at the actual data, we have given a lot of, and actually the amount of time we take to give patents is lesser than most countries. The average time, and this was actually not only written into the negotiations, but it is actually very well described in the Canada, EU-US Canada dispute, okay? And it takes an average of 8 to 12 years to get the regulatory approvals. So you may get the patent on day one, but the regulatory approval will be average of 10 years. So the monopoly is only 10 years. So that's written into the TRIPS agreement. But we are giving it much less than that. So they get much more, but still they want patent term extensions. So how do we deal with that? The problem is the lobbies in the US, and they are against the academic community. I'll come to your question. They are intent, because this is easy income, is rentier income. You know, no, it's like you have a house, you keep on getting rent for the rest of the life. You don't have to work for it. It's classically known, and Montague is a well-known economist. I'm just a lawyer. Rentier income is the easiest thing. You don't do anything. You get it, and then you keep on getting the thing. They don't want to give up. You have something you don't want to give up, but it is not working. Okay, and it's not only medicines. In fact,
if there is a caveat, some people have argued it's only for medicines. The rest of the sectors, there is zero evidence that it works. Software, anything. I mean, if you want to, this Economist had carried, you must remember, last year only, the Economist carried a huge piece, sort of a section about IPRs, and it's based on a book by 2 authors in the US. I'll send you that if you'd be interested in that. Please read that. It's very extensively documented, and actually it's the other way around. They will argue that in case of medicines you can make out a bit of a case, but not really. So I think the way is basically we have to actually advocate and sensitize and pedagogically educate parliamentarians and large number of bureaucrats. Within the bureaucracy there is a lot of knowledge. For example, DIPP, there are a lot of people, they know a lot of it and they are very strong, and I feel that they will be able to carry the ball because they have been trained from those days, and those who are continuing know it, but the newer people we don't know. And then also there are compulsions of governments, because now the government wants to show that we are friendly, so there is a tweaking of that policy, but there is no fundamental change as I see it. So I think we have to be more active, and I think as Montagji says, we have to advocate more about these issues, go more public about whether in fact patents and IPRs result in innovation. In fact, we made a very strong argument within the IPR panel, okay, but they just didn't, I mean they have not considered it at all. I was surprised. I know Justice Prabhashiri Devan, she was heading the panel, and even Pratibha, who is a colleague at the bar, she's done mostly generic work. She's now actually appearing for what is that company, Sofu, Gilead. So she's appearing for Gilead, she's entitled to, but she also knows, but somehow they've come out with this thing about IPR must be known to every child. I just don't understand the logic of it. It's like popularizing IPR for what? I just don't, I mean it doesn't okay, who's this? Your question I've answered. Your question. Okay, evergreening is not the same application. Okay, in the US there is a slightly different procedure. They have a procedure for continuing application. That's not what happens. Suppose you have the patent application in the base, you discover a salt. Actually salts are easy to make, but suppose there is a genuine innovation of a salt, assuming that, then you have to make a separate application. So the base will be in say 1980. Salt will be discovered or invented in 1990. So there is a 10-year gap. Okay. Now the salt will be sought to be patented. So the original patent application is 1980. It will be over by 2000, and this will last for another 10 years. But they are not going to use the old one. Nobody is going to use the old one. Remember that. They will want to use the salt one. No doctor will say give me the base. Okay. But it has the same original chemical, which is the active ingredient, and then you have a crystalline form which is pure. Crystallines are pure. When you want a pure form of the product, you make crystal, like sugar crystals. They are pure sugar. Okay. So, or the salt, for example, the sodium chloride that we eat every day is pure product of salt. So it's actually made in that form. But if you get a novel form of crystals, because there are different forms, that's why they're known as polyform, multiple forms. So you can have A, B, C, D, and they may have different properties which may be advantageous, like the beta crystalline form was. So you patent that, and obviously I'm not going to keep a crystalline form in my laboratory or in my clinic if it is hygroscopic and actually attracts water, right? So everybody will be marketing in the new form. So they get the extension by different application. That is what is known as evergreen. Sorry.
I'm also worried about this. But this is the case. What you're really saying is like, imagine if itself, the base, just passes through the body.
Not passes. It may pass like alcohol.
Yeah.
What passes through the body is alcohol.
But
it goes in and comes out.
It's imaginative methylate.
Methylate, yeah.
That is actually has some.
No. Sorry.
Right?
Let me explain to you. The active ingredient is imatinib.
Correct.
The salt will give you solubility.
Correct.
And the crystalline form will give purity.
Well, I was under the impression that if you just consume imatinib, it just doesn't absorb in the body.
Correct. It will have less absorption.
Now you have imatinib methyl.
Massive.
Then these guys have invented the beta crystalline form.
Correct.
But you're telling me that we would not, of course, I'm in favor of 3D, so it's not an issue. But say in the United States, if they were to actually patent
Mesylate.
the beta crystalline form,
Yes.
but the methylate has gone out of patent, presumably a generic guy can still produce it.
Yeah,
Now,
that.
there are only two issues.
Correct.
If the fellow is getting rentier income, then one is cheap and the other is expensive.
Yes.
The real problem is that doctors don't recommend.
That's also another thing.
Most of their research expenditure is actually taking doctors.
You're right,
and
you're right.
their, what they call it, your significant others.
Yeah.
On cruises and all this. No, really.
Oh yeah, it's very well documented.
Well documented. So I think half the problem there is the fact that the doctors get sort of succumb to the temptation to recommend the latest thing, then they take the other thing off the market. But
Correct.
a generic producer could produce it.
Good. No, that's one aspect, and that also works both ways. But the real problem is not that. If you look, that's why I showed that data of FDA. Why are 76% or 85% new forms? By incentivizing both new chemical entities, which are new, genuinely new drugs, and formulations, you are actually allowing the same incentive, that more exorbitant prices, to two different products. One is a genuinely new inventive drug, the other one is not. You are disincentivizing new chemical entities. That's exactly what has happened in the US. And that's what I argued with the US administration. You should adopt our 3D, because if you want to really have, in fact, over the last 20-30 years, NCs have actually dropped down over a period of time. You're not getting new drugs. You're getting a few, and there'll be blockbusters. But really, genuine inventions are coming down over a period of time. This is because you're incentivizing new forms and genuine new drugs at the same level. So that's one answer. The other thing, I think, there was another question by that gentleman.
I just wanted to bring you notice the data security.
No, I'll tell you. There are two things in that. One is, you see, once the drug actually is invented, you make an application for a patent. Then you have to make sure that the drug actually works in the real world. Okay, a chemical produced in the laboratory is new, it's inventive, it can be used, but is it going to work? Because human beings are different. In one country, another country, men, women, transgender, everybody is different. Is it actually going to work? And that's the pharmaceutical industry thing. Out of 100 drugs, only 2 of them actually are really blockbusters, etc. So they are completely wrong on the actual maths of it. But those things have to be done. Now, the data which is used, which is generated from those studies, is given to the regulatory authorities. The regulatory authorities will see, is it safe, is it effective, is it efficacious. On that basis, the drug regulatory authority, our Drug Controller General of India or their Federal Drug Administration, will give the drug marketing approval. Okay? What they are saying is, until now, that data is available to the drug controller. So the drug controller, when he gets the generic company, now it's gone off patent, the generic company will come and give their data. They don't do the clinical trials, phase 1, phase 2, phase 3. They will give data what is called as the bioequivalent studies. My drug is equivalent to that drug. Okay? And for that purpose, the drug controller will say, reference drug of the innovator company is safe and efficacious. And this is equivalent to that, therefore this is safe and efficacious. Now just imagine, what they are saying is, the drug control, that is what is called data exclusivity. They cannot use, the drug controller cannot use the data of the innovator company to decide whether this drug, the generic company drug, is safe and efficacious. Okay? They want extension. Even if there is no patent, they will get a monopoly of 5 years. But the wrong thing in that is, suppose you have data in the originating company which is deleterious, you can't look at that also. This is completely wrong, because you will say, I will not look at the data which is bad to find out whether this should be allowed or not. Okay? Apart from the fact, which is the traditional argument, that you never experiment on human beings once we know the drug is safe and efficacious. That's an ethical argument. So the data which is available should be used by because it's drug, the data is available to a public authority in public interest. So the public interest should prevail over a private interest. But where they introduce it in say Jordan, and there's a very good study by Oxfam, the drug prices because of data exclusivity went up by 1500%. Okay, that's one thing. Second thing is, I don't know if you've read a book called Bad Pharma. Please read it. There are bad lawyers, but the bad pharma is like takes the cake. When these studies are done, clinical trials, phase 1, phase 2, phase 3. When bad data comes, that 3 people die, sorry, they don't disclose it. There is no law obliging pharma to disclose it. That has been the fight. And the author of Bad Pharma, an English surgeon, has been waging a campaign for the last decade to make sure that bad data which is collected, meaning I tested this drug, phase 1 is healthy people, phase 2 is intermediate, phase 3 is large and actually affected individuals. So you go from the stronger to the person who are debilitated with that particular ailment. And if you don't have that data, how is the drug regulatory authority going? This is a major, big black hole in the pharma data collection. They just don't tell you anything, and there is no way you can get it. There is no law requiring it. And that's the big struggle going on within the medical community who want that data. But the pharmaceutical industry is not giving it because there is a lot of bad data which is just not revealed. And it's a top secret within the companies. I mean, anybody done corporate, right now I'm the 2G special public prosecutor, I don't want to say it, but straight shooters are very few, very few, very, very few. Because the competitive world is so competitive. I mean, forget the patents. You need to be there first in the market to make the first killing. If you are not there, you are useless. So the pressure on you is so huge. And there's a very good book, an old book, which like for me it was a Bible when I started off as a biochemist, called Corporate Crime. It's all about how corporates commit crime in the pharmaceutical industry. And actually it starts off with a very sad thing about the Nazi regime. But I don't want to bore you with that. Bore in the sense, it's not pleasant. But it all talks about why even people who don't realize what they are doing, they are committing a corporate crime. Because the incentive to get profits is so strong. If you go to a doctor's clinic now at this time, 7:30, there'll be about 10 salesperson, like what you're saying. They're all there. This drug, that drug. That's the huge thing. Whether it's actually working or not, the doctors don't know. They really don't know. They don't have the time. They don't have the time to read the literature. So it's not an easy thing. Last set of questions. Oh, Shruti.
Her first and then. Okay, and then him and then.
Oh, we'll have the full, whoever wants, no problem.
Okay, I think first Shruti can ask a
Thank you. My name is Shruti, and thank you for this very, very fascinating talk. I wanted to zoom out a bit and ask you, what are the hopes in the bigger, in the challenges at a larger level of using the right to health arguments and the chances of success of building bridges between business and human rights. Just zooming out of these very technical kind of, what do you see is? And also, if you have time, I wanted to ask you, why is what is the secret of the history of, the unique history of Indian generic pharmaceutical industry?
This is Gandhi. Simple. No, but see, Tekchand, Iyengar, see, I mean, this is very interesting. I'll answer that it's very important to realize this. This is very important, I think. Yes. Whoever, yeah. There were some people here. 2 people. 3.
I'm Shams Paja. Anand, my first question pertains to you as an expert in the area. If we were not talking of the present regime and the legal protocols, and we were in a free thinking forum, what would you suggest as an alternate to idea, if any? The second goes to you at a higher pedestal, you being an eminent jurist. Well, that's what I don't know.
I don't want to say defame me, but please don't say that.
The fact that you pointed out, there is a chink in the armor. Our sovereignty is compromised.
Sorry?
Our sovereignty is
Sovereignty.
compromised. So what are your ideas as to where and how can we tweak our constitution to ensure that the people of India are really sovereign? Thank you.
Yeah. Hi sir, I'm Pramod.
Sorry?
I'm Pramod.
Pramod.
Well, the questions I'm going to ask, I'm myself a little doubtful over it. But I'm asking. Well, the whole election, all what I heard, and the thing which I can conclude that big corporates want to make their profit, the criminal profit, under the guise of patent law. This all I could understand through all this. So I want to say when
I hope that's not the only thing.
So I want to say when these bilateral investment treaties are being signed, why don't we fix a ceiling price for when they come into market? So that ceiling price has to be fixed earlier. So you cannot raise your pharma products price more than that. Why we cannot do that?
So there are two more.
Good evening, I am Somnath from Hamsraj College. Your talk was wonderful and informative, sir. So I would like to have your opinion on one thing. Were you referring to the pharmaceutical research and the manufacturers of America as which acts like a mafia group in the pharma industry? And so the Vice President of PRM had remarked that the Indian governments and Indian courts don't recognize the value of innovation and intellectual property. So how do you respond to that?
Hello, sir. I'm
Anand. Anybody calls me sir in my office, they are shown the pink slip and out of the door, even if they are younger than you.
Hello, Anand. I'm Kashishti Bhatt from National Law University, Delhi. So, on a side note, I just wanted to ask you whether you could share some anecdotes as to how, during the case, I'm pretty sure you would have interacted with international civil society groups such as Doctors Without Borders and other NGOs or organizations and entities who do wonderful work in India. So, could you please?
Okay, that's it. Yeah. Well, I think that's a very important point, Shruti. Business and human rights actually is a growing tribe of not only human rights lawyers and human rights academics, but even business persons who are looking into this because they, I mean, I'm a leftist, socialist, communist, whatever you want to call it, but I believe that large number, no, this is a serious thing, large number of businessmen want to be responsible. And in fact, no, this is from my work as the UN Special Rapporteur, and there's a report by John Ruggie on business and human rights. And the people we interacted with, see what is happening is that though there are large number of people because of the competitive world who have gone down the road which is not good, there are a number of people who have reacted to that. They don't want to be part of that. Ordinary people and human beings and even corporate don't want to be part of a dirty game. They want to be competitive. They would rather play straight. They don't want trouble. At the end of the day, you get into trouble, you know. I don't want to talk about individual personalities. So I think there's a growing group of civil society, and one of my friends from Sri Lanka, she has the same name as the last president, so not a very good name in that sense, Rajapakse. So she actually runs an entity which is set up by business persons and business entities in Brussels, which actually looks at compliance of human rights standards throughout the system, and they are actually becoming a larger tribe. So we have to see, we are living in a capitalist society. There is the human face and there is the other face. We have to try to change things with human rights embedded in this society. So I strongly believe that you have to, and I think Montaigne made the point, you have to advocate. I really believe that you can change things. I have been very active in HIV. We were able to change people's views on very difficult things, like 377. I remember when Sushma Swaraj, I have a lot of respect for, yesterday actually the Air India flight which landed in Kazakhstan. You know, my Indira's nephew was on the plane and she tweeted to her and she said, no, we are doing something. So she is very responsive, and I remember her when we were advocating condom promotion through television media. She said, but if my daughter looks at this, what is going to happen? She had that apprehension, but he was open about it. And then we articulated and advocated with her, and she changed her mind. And she became the proponent of it. So I think there are large numbers of people like that who you can change. They don't want to be part of the dirty gang. Even business people want to play it straight. They want to go and sleep home without any, sort of kind of thing. So I think there's a huge groundswell of that coming up over a period of time. So I think we have to really forcefully, I don't agree with John Ruggie's position, but I think you have to articulate that. And the Human Rights Council is becoming a very big issue. So I think business persons have to be involved in human rights issues in terms of how they respond to, say, minimum wages, child labor, okay, those things. Does a business entity like Tata want child labor? So though they don't want it, I know that for a fact. Large numbers don't want it. So we have to advocate within the business community, and there's a huge opening there. Even on corporate social responsibility, of course the government is trying to tie it up. There also we can work. So I think there's a large number of advocacy to be done there. Alternative to PR is open source. Okay, open source work. There is a very good example of our own government departments. They are putting everything on the web, and anybody can contribute. Before patents, large number of discoveries and innovations took place. You don't need patents for that. So you can have open source discovery as it is. There's already alternative available. Sovereignty, I answered that question. You need to change the law actually.
Where in the constitution? That was my question.
There are different methods of doing it, but I think you can have a system either like the US or other countries where they say that you can amend the constitution so say that any treaty, because right now there's only a small provision in the constitution, the executive has a co-extensive power. So you can tweak that to make sure that any or certain type of treaties which have implications in economics or whatever, they have to be ratified before they are actually. Other countries do it, you can do it. Prices of you said, huh?
I said, why a CV agreement has not been fixed?
No, that you see the problem is even there's a big issue on whether the drug price control order has worked, because the drug price control order, there's a huge litigation on that, and right now CIPLA is fighting a litigation. The civil society is asking for price control of a lot of drugs. I am part of that civil society, but I have also seen the generic industry and the innovator companies. Generic industries are subject to a large number of price controls. It is required in one sense, but what is happening now? Today, I'll give you an example, and this is a challenge, and it's very important to understand it, and very few people are picking it up. Today, what is happening is, say there is a bid for, inviting bids for procurement of a particular drug. Most of the top generic companies are not filling the bids at all. They don't want to go into the procurement system. Why? Because there are 3 levels of quality today in India. One is the drugs and cosmetics level, the other one is the WHO pre-qualification, the third one is the US FDA. Now say CIPLA is US FDA qualified. For that you have to pay a lot of money to get the approvals. You are competing with a person who is at the lowest level. So as an example, Rajasthan Medical Services Corporation, they had a bid for Gleevec. Novartis was selling in the open market for 1,20,000. They went to Rajasthan Medical Services Corporation, which is a good entity and actually done a lot of good work. They said that we will give it you 8,000. They said, sorry, come in a bid and bid. If you win, you win. They didn't bid. CIPLA bid for 2,500 from 1,20,000. You know what the bid was? Which was 750 rupees. So CIPLA cannot compete with them, and they're the best quality compared to say any Novartis or whatever. Similar thing, they go and bid in the NACO for HIV antiretrovirals. What happens? They can't get their money back. They are not paid the price which they are bound to be paid, because it's delayed and there is corruption. You want the money, pay this much. Some goods are bad, so they are not bidding anymore. What are they doing? If you look at the data, CIPLA 15 years ago, domestic market was about 60%. Today is the other way around. we are selling it abroad. You are pushing the generic company to go abroad. It's a very dangerous thing. And this thing is going to further increase it. And nobody is looking at it. And all the generic companies are complaining. They're not being listened to by the government. And we have the Make in India, which pharmaceutical industry is the best example of. If you go abroad to Africa, Latin America, or more than computer software, it is the pharmaceutical industry which is known. People will bear me out, anybody who goes abroad. Software is only in the US, or a few other countries, or Europe. But in Africa and in Latin America, of course, we are not known for our sports. I won't talk about that. But that's also a systemic thing, nothing to do with the. But the point is, they will tell you, Africans will tell you, you don't play football, but you produce very good medicines. Okay? Look at another problem. I was in Uganda. We have the best generic Indian run industry in Uganda. But what do they know? The Chinese have set up a hospital. Because the government in China is supporting the embassy. Our embassy is not doing anything for the generic industry. Sorry. Nothing. The Indian outposts are not really supporting the Indian generic industry. And I have a very close friend who is now our ambassador to Belgium, Manjeet Puri. You must be knowing him. And he also complains of the same thing. There is support, but not for the, and they have very good people. I lost my passport because my whole bag was stolen, and within one day I got a replacement. Very good service. But they don't, the systems have to be put in place, and I hope that can be done. Well, yeah, what you asked me, the Pharmaceutical Manufacturers Association, the cowboys. I'll just use that phrase. You understand that. Medicine, somebody asked. Last question, what was that?
MSF, International Organization.
Yeah, MSF. What was the question, MSF? Oh, yes. You asked that. You asked. Okay, no, I'll tell you. The access to medicine work is actually run at an international level with the cooperation of a large number of civil society members. So we have groups in South Africa. Medicines Sans Frontières basically delivers medicines, but they are very much part of the access to medicine campaign. Okay, but there are groups in South Africa, Kenya, Uganda, Brazil. We all work together. So everything. So for example, in Ukraine or Russia, sofosbuvir is needed. So we have the data throughout the world, civil society. What are the patent applications? What are the prices? So we work in conjunction with each other. In the Novartis case, the campaign was run by MSF. We are the lawyers, we can't do any campaigning, so we didn't do the campaigning. But they cooperate with us in terms of exchange of information. And they also are working closely with the, I don't want to call them patients groups, but the people living with HIV, people living with cancer, because the work that we do, whether it's MSF or Lawyers Collective or other groups like us, we empower people. They know, for example, this is very important to understand, the Lawyers Collective work is not based on what we do. We empower those groups, make them aware about patents, about the drugs. So if you go to a person living with HIV, the Delhi network of positive people, if you go there, ask them, okay, about the drug. They know more about the drug than the doctors. They know more about the patent status than any doctor. Because from 2000, and I'll tell you this anecdote, we started work because we knew 2005 the patent law is changing. So I, as a madman, said, okay, let's go and talk to all the people living with HIVs about patents. So we started talking. We had groups, workshops like this, and all people with hepatitis, HIV, drug users, etc. They would come and they got to know about patent. But then we thought, well, it's not working. Nobody's really responding. We stopped. Within 1 year, we had a request again. Where are those patent workshops? We want to know more about it. And when 2005 came around, they were the ones telling us this drug has to be opposed. So it is the patients groups. With us, we decide which are the drugs which have to be opposed. Because there are large number of drugs. We can't oppose all of them. We have very limited resources. I'll tell you, like for example, now of course the next drug I'm doing is for a generic company, Natco, Allotinib, okay? They have a lot of money. They are ready to pay, and I'm ready to take up. I'll tell you very clearly. So it's good money in patent law. Actually, it's very a niche thing. But when we do work for the NGOs, there is no money involved, but the work is the same. And it's a lot of work. I'm doing a cross-examination in Calcutta on another patent, and it takes 5 days, but the preparation takes 2-3 months. It's not like an ordinary case, which I'll do in 2 days and start arguing, because the technical details are very, very. You have to know your chemistry very, very well. So, but I'll tell you an anecdote from the Novartis case. First of all, well, I don't know whether I should say it so clearly, but there were reports in the press that certain judges have recused themselves because they were being educated about patent law by Washington University. That's the level of penetration of the pharmaceutical manufacturers. They have an agenda. They will say, we will teach your patent examiners what the law is, and they are doing it. We will teach your judges. So thank God we have judicial academies where they can't come. It's about propaganda. This has been going on for years, and it will go on forever. Nothing new about it. But we should be, it's a debate, it's an open society. We should articulate our point of view. I'm not saying they can't come, but they can't teach our people. We have to teach our law to them. Thank you very much.
Thank you very much, Anand, for coming and giving us this insightful talk. We'd like to give you a small token of our appreciation.
Oh my God. What is this?
Thank you, sir.
Thank you. Thank you very much.
Thank you for the talk.
And thank you everyone for coming.